The Honorable, the Supreme Court.
Good morning, everyone. So, thank you very much, and please be seated. In our previous hearing, I want to again welcome our two new justices to the bench. It's a pleasure to have them here. Having said that, when the live stream is ready, please call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled 32 Intervale LLC et al. V. City of Burlington. Case number 25 AP 248. Representing the appellant 32 Intervale LLC is attorney Liam Murphy. Representing the appellee, City of Burlington, is attorney Malachi Brennan. Seated at counsel table with attorney Brennan is attorney Rachel Seelig and attorney Kimberly Sturtevant.
Okay, to the appellees, are you splitting up time when you argue? No. Okay, great. Thank you. So we'll hear from counsel for the appellant first, of course. Please come on up. Start by introducing yourself and your client, if you will.
Good morning, Chief Justices and other members of the bench. May it please the court, I am Liam Murphy of MSK Attorneys, and I'm representing the appellants, 19 property owners with various properties which were rented as short-term rentals prior to the adoption of the City of Burlington zoning ordinance and minimum housing ordinances, which together limited such rentals to owner or host occupied properties. This case involves a question as to which court has jurisdiction in a situation where an ordinance is adopted intertwining two separate statutory provisions and each with its own appellate path. In this case, the appellants are now currently stuck between two decisions. One, a ruling by the civil division upheld by this court that the city's short-term rental ordinances arise under 24 VSA Chapter 117, which authorizes zoning, and the appellate path for which is the environmental court. This court directed that the matter be heard by the environmental division. And the environmental division, 2 weeks after this court made its ruling, made a decision that the ordinance is not a zoning ordinance. It's actually a minimum housing ordinance, and therefore it did not have authority to hear the case. And without this court providing some guidance and clarity as to the scope of the jurisdiction of the divisions, appellants cannot obtain redress from either the civil division or the environmental division. And this lack of ability to appeal really is inherent in how the City of Burlington went about adopting their new ordinances.
Attorney Murphy.
Go ahead.
Thank you, Justice Eaton. Attorney Murphy, is it perhaps your case is not ripe?
No, Your Honor, it is. We have these apartment owners that were and continuing to occupy or use their units as short-term rentals, and any day they could be subjected to an enforcement proceeding.
But they haven't yet.
They haven't yet, but that the courts have been very clear over time that a party doesn't have to wait for an enforcement action. In the court in 2024 in Echeverria, the court says it would eliminate the reason for the DJ action to force a party to wait for an enforcement action, be subject to penalties. But
Attorney Murphy, in Echeverria, there weren't many facts that had to be still determined. And in this case, with all those landowners, I think declaratory judgment is not appropriate when there are still so many facts that, that the court doesn't know.
Well, Your Honor, I think the declaratory judgment has two elements to it. There is not, the court has said that there can be fact-finding in cases where it's necessary to determine the legal consequences. That was in the Commercial Insurance Company of New Jersey versus Papandrea. And here, what the court first has to decide is what are the legal criteria for properties to become considered pre-existing non-complying units. That's a legal decision. And then the rest is easy. It's just, did they meet those facts? Were they in operation before 2022? Were they legally approved? So being legally approved, those are usually the two elements of that. So the application of the facts are not facts that are just facts to that need to be determined by the court. It's really an application of the facts once the court makes the determination of what the legal criteria are. And that's what we've asked. And it makes a lot more sense for these 17 unit owners to go in and say to the court, here's a range of issues. Tell us what the legal parameters are for pre-existing non-conforming uses, and then apply that law. But we've never been able to get there because of this procedural problem.
I have a couple of questions.
Of course,
I'm sorry to interrupt you. Why not go to the zoning officer and ask the questions about what they're going to do?
so
That's point one.
much
Have another.
much has been made of this provision of the ordinance that says you can seek a determination of non-applicability, the city calls that. And what a determination of non-applicability is under section 3.12 of the ordinance is that the administrator officer may make a written decision that a zoning permit is not required. That's the question. So you ask that question. But the problem here is the city's ordinance that they just amended says in 3.12 that exemptions shall be, the following shall be exempt from the requirements of this ordinance, the entire zoning ordinance, and shall not be required to obtain a zoning permit, short-term rentals. So it's illusory. You go to the city and you say, I want a determination that we don't do or don't need a permit. They say, you don't need a permit because you're a short-term rental. But there's the rub. How do you, who's to decide it's a short-term rental? And the way the city has set its ordinance up is in order for you to be a short-term rental, you must show that you are a short-term rental pursuant to the other statute, the minimum housing statute. And therefore, you go to the zoning administrator and you are in the same position as the environmental court. The zoning, if Your Honor,
Yeah, please.
one
please.
moment,
I'm
I'll
sorry,
finish.
I don't want to.
The zoning administrator doesn't have jurisdiction to make a determination that you comply with the minimum housing ordinance. So the question of whether you can get a determination of non-applicability is illusory because they don't have the power, because they've split the cases into two different entities, both of which have different administrative officers and different appeals, and neither can make a decision about the other. And that's how we ended up here again. And we will do the same we'd be in the exact same place if we go and apply for that determination of non-applicability, because the zoning administrator is going to say, I can't make a decision. The public works are going to say yes or no, but when you try to appeal that, the civil division says, we have no jurisdiction, go to the environmental court. The environmental court says, we have no jurisdiction, go to the civil division. So in this case, normally, it would make some sense in cases to so-called exhaust your administrative remedies. But it also makes more sense when you have multiple parties, 17 parties, all seeking the same legal determination to combine that into a declaratory judgment.
So what exactly is the mandate that you're looking for here? What, if we were to agree with you, what is it you want us to say? What, spell that out?
Yes, Your
for me,
Honor, I
would
think
you?
this comes back to the environmental court's view of its jurisdiction. The environmental court traditionally has a very narrow view of its jurisdiction. 24 VSA 4472 says an interested party's exclusive right of an appeal of a act or decision of a municipal body is to the environmental court. The environmental court has taken that sentence or that provision and said, it's not a limitation on the appellant, it's a limitation on the court, which is incorrect. And this came up 2 years ago in the Rainey Dairy Farm case where this court, the environmental court had said, we don't have jurisdiction to make any decisions about private property rights, and therefore we can't make a decision on the zoning aspect until you go to civil division and get a decision on property rights. And this court said, no, where the decision is inherent in making the zoning decision, then the environmental court has that jurisdiction. And I think that would be the same case here. I think what we're asking the court is to say to the environmental court is, yes, this may include some determination of minimum housing standards, which is normally a civil division, but because those have been incorporated into the zoning ordinance, you, the environmental court, have the authority to make that determination as an inherent power of the environmental court. The environmental court could say, well, for us to make a determination that is or is not a short-term rental, we have to make a determination that under the minimum housing standards, and therefore they have giving the court the right to that more expansive power would be the way to do it. I would like to hold the remainder of my time for some potential
Okay.
rebuttal.
All right.
Thank you.
You. So we'll hear from counsel for the appellee. Please come on up. And if you would, start by introducing yourself and your client.
Thank you and good morning, Mr. Chief Justice. My name is Malachi Brennan, and I'm here from SRH Law representing the city of Burlington. The heart of this case is appellant's refusal to exhaust the required administrative remedies. The jurisdictional issues in this case and the prior appeal to this court could have all simply been resolved if the appellants had asked the city's zoning administrator for determination of non-applicability. We're not even getting into the merits of what that determination might be. They simply just needed to have asked, and the city's position has been from the outset of this case, had they asked, they would have had a appealable determination to the environmental division.
But your, go ahead. But your colleague says that there are aspects of this determination that are outside of the zoning administrator's purview. And therefore, he says, essentially saying it's a push me, pull you. What do you say about that?
Yes, thank you, Justice Eaton. So there's a couple of dimensions here. First of all, the appellants are speculating as to what the jurisdiction of the zoning administrator might be, and they haven't even asked. We don't even know how the zoning administrator might interpret the zoning ordinance and whether it even requires consideration of the separate short-term rental ordinance. So we're essentially asking the environmental division for an advisory opinion about what that jurisdiction or determination of the zoning administrator might be. I think it also makes the point very clearly that these ordinances are separate. There's a short-term rental ordinance that is part of the city's minimum housing standards that requires annual and ongoing registrations by anyone who is doing, whether it's a long-term rental or a short-term rental, that apply health and safety standards for dwellings. And that is separate from a zoning ordinance. The zoning ordinance simply has a definitional cross-reference to the minimum housing standards that helps the zoning administrator understand what a short-term rental is, but that doesn't incorporate by reference the entirety of the minimum housing standards.
We had the same question.
Thank you, Justice.
And then I have another one. Maybe we can go 2 for 2. All right. The complaint here says, and I'm reading it, it says it in several places. Despite this, the city has refused to issue the necessary permits to several properties that are in compliance with all city regulations other than being STRs. What is that referring to? Are you aware of anything? I could not find a refusal of permit in the record.
I'm not aware if those refusal of permits are in the record, Justice Eaton. And I think, again, that question is secondary to the jurisdictional question of the environmental division can consider whether that has occurred or not once they take the proper steps to bring it before the court. I'd like to begin with there's actually multiple jurisdictional grounds why the environmental division was correct to dismiss this case, each of which do not require this court to consider whether these two ordinances are intertwined or any of these arguments that appellants make on the merits. Each of those grounds were correctly decided. The first is ripeness. This case is not ripe because the appellants have avoided the process to properly bring a zoning dispute before the environmental division. We've talked about that a fair amount this morning, that there's a process within the city's ordinance that allows a zoning administrator to issue these determinations of non-applicability. What the applicant's complaint asks for is a declaratory judgment that their properties are non-conforming uses. A non-conforming use is a matter of zoning law, and a determination of non-applicability is exactly how you get a judgment either from the city or from the environmental division sitting in the shoes of the city about whether your property is a non-conforming use. You're essentially saying the new zoning bylaws do not apply to my property and I do not need a permit because I was a prior conforming use and I no longer.
Does their position essentially create an opportunity to just jump over 4472's process?
That's exactly right, Justice Eaton, and that is our serious concern in this case. Like, the city is not making this argument as a procedural hurdle. In fact, we have advised appellants from the beginning that the proper way to go about getting their case heard in the environmental division, and we submitted this motion to dismiss, asking that it be dismissed without prejudice for them to have this opportunity to come back. Because we are really concerned that if the court adopts the appellant's argument here, it would allow any party to skip the zoning process, go directly to the court, and then require whether it's the city or other municipalities to expend significant resources dealing with these cases in the environmental division instead of by the administrative process that's been set forth.
Can you please help me understand, if the appellants go to the zoning administrator, and I appreciate nobody's predicting, but in the event the zoning administrator does what Mr. Murphy predicts and says, you don't need a permit, what are appellants' next steps?
Yeah, thank you, Justice. Any act or decision of a zoning administrator is appealable. So understanding if the zoning administrator says you don't need a permit, most applicants would say, thank you, I'll continue with this use or take that into account. But that is an appealable decision. And if they thought that the zoning administrator should have considered this separate short-term rental ordinance, rather than going to the city's separate code permitting department who manages the rental registry, they can appeal that act and they'll have an appealable decision no matter what the zoning administrator says, that they can take to the city's DRB, and then they can take that to the environmental division. They don't need to have 17 separate cases either. They could have simply had a single test case where they pick one of the appellants and see what happens. That's the environmental division, and they'll have their answer. I want to briefly address the idea that this is a standalone zoning case. These type of decisions, whether it's a determination of non-applicability, excuse me, or the question of whether a use is non-conforming is one, as Justice Waples pointed out, is a factual determination that requires a decision of what was the use prior to the change in the bylaw? What is the use after the change in the bylaw? Has it enlarged? Has it changed? Is it still legally a nonconformity? That has to be determined for each of the, the applicants. And in the appellant's complaint, they note in paragraph 56 of their complaint, which is at PC 30, that some of the plaintiffs commenced rentals before the change in the ordinance. That implies that not all of them have. So there will be factual determinations of when these were started and whether they're actually conforming or non-conforming, if we go along with their argument.
Are they able to show injury here for purposes of a declaratory judgment?
No, Your Honor. There has been no enforcement action. They are currently, as far as the city is aware, continuing to rent out their rental units and profit from them while not complying. And they concede throughout this case, they have conceded that they do not comply with a short-term rental ordinance. They may or may not comply with the zoning ordinance, well, depending on what the zoning administrator says. But it is not disputed in this case that they do not comply with a separate short-term rental ordinance. I want to briefly talk about comments from the appellants that they're stuck with no appellate path. There's a very simple appellate path here, as I've discussed in the city, is our view in this case. There's two separate jurisdictional issues. In the civil division, it was subject matter jurisdiction. Here it is ripeness. There's no catch-22 and there's no disconnect between those two. And lastly, if there's no further questions, I'd like to briefly conclude. This case may be resolved on these straightforward and well-settled jurisdictional principles that we've been discussing. And the environmental division was correct to dismiss it, and we asked the court to affirm on those same grounds. But in closing, I wish to note on behalf of the city that the short-term rental ordinance was enacted following a legislative change just a few years prior. And it was done so to address an ongoing crisis in affordable housing in both the city and throughout the state. And the civil division, in a prior motion for summary judgment in this case that was not appealed to this court, but was fully litigated on the merits, observed that this is a legitimate exercise of the city's police power to protect the welfare and health of the city's citizens. And so on that basis, I would ask the court to also affirm this case and not create a loophole.
Thank you very much. How much time does the appellant have, please?
Appellant has 3 minutes and 41 seconds remaining.
Counsel?
Thank you, Your Honor. I'd like to commend my colleague on his presentation and on how he avoided a number of the questions that were asked. The questions by Judge Eaton about what would be the outcome of the non-applicability application, he said, it's speculative. Didn't say that it would provide any resolution to the appellants. And in regard to your comment about the refusal of the city to issue permits to the appellants, that is correct, that because they are not complying with a short-term rental ordinance, they are not allowed to obtain any other permits for their properties under the doctrine of clean hands. And in the response to that was not a response of yes or no, it was, well, that's secondary. It again didn't address the issue. And then in the question from Justice Drescher about the appeal to the of a decision to the environmental court, he says it's a simple path. Well, the simple path problem is that if any appeal right now goes to the environmental court under this ordinance, the environmental court has said it doesn't have jurisdiction because it's a minimum housing issue. And and if you go to the minimum housing, the appeal to the civil division says it's a environmental court issue. So despite whether or not the applicants would be required to obtain a certificate of non-applicability as to exhaust its remedies, this court has to sort out this dichotomy where neither court says they have jurisdiction in an appeal under those matters. And as I mentioned, I think the best method to do that would be to give the environmental court the authority to undertake analysis and make decisions about compliance with the minimum housing standards in cases where those were inherent in an environmental appeal. Finally, there's a question that we haven't gotten to at all, and I just want to make sure that the court is aware that in its decision, the environmental court made a pronouncement that the doctrine of pre-existing non-complying uses and structures were not available in the context of minimum housing standards. We believe and would ask the court to rule that that was dicta. It was never briefed. It was never argued. It was purely a commentary of court. It was not necessary for the court to make that decision in order to rule on the case. And we would hope that that would not stay without explanation, that that was not binding in any way. If there are no questions, I'm all set, and thank you very much.
Thank you very much. Please call the conclusion of the hearing.
The next hearing for the court is scheduled for 10:45 this morning.